Good morning. I am at the Roseville Gibson Courthouse. I'm going to be arguing a motion this morning. Too Dumb for Lawyer has rejoined. Again, it's like the guy doesn't understand. I have literally shown him Supreme Court cases stating exactly what he had an objection to, and he just resets. He offers nothing. He says that custodial arrests are in Terry v. Ohio, and they're not. So I have no idea what the guy's on about. But we'll try again because, well, why not? He starts off, and I'm paraphrasing, so I'm sure he'll nitpick that I'm straw manning, but you can read the comments yourself and figure out if I'm actually trying to address it. He says if you guys are, meaning me, I guess, are done trying to pull custodial arrest out of the reasonable suspicion category where Too Dumb for Lawyer had firmly placed it, then he wants to continue. And we can't. You cannot pull arrest. You can't stop pulling arrest out of reasonable suspicion because arrest doesn't belong in reasonable suspicion. Custodial arrests, if he's going to get hung up on the term custodial, I'll throw custodial. Just assume anytime I say arrest, it means custodial because the court doesn't deal with any other kind of arrest. There's two kinds of seizure. There's a detention and an arrest. And an arrest is custodial. There you go. Enjoy. So anytime there is an arrest, it has to be based on probable cause. Now, I've seen comments, well, what happens if the officer makes an arrest and it's determined later there was no probable cause? Well, that's pretty simple. For terms of suppressing evidence, that's easy. Any evidence uncovered after the arrest that was not supported by probable cause is going to get suppressed, generally speaking. I mean, it might not, but the first thing that the defense attorney is going to do is going to suppress that evidence. There's going to be a suppression hearing. He's going to say, this is the fruits of an unlawful arrest. So, but beyond that, all the protections that go to the defendant after being arrested would have still come into play. Miranda rights would have kicked in, the right to counsel would have kicked in, blah, blah, blah. So the only thing you really have to worry about is suppressing evidence, unless you're trying to think, well, can I sue the guy? But in which case you have to remember cops are allowed to make reasonable mistakes of fact and law. So there's a whole different calculus that would go into whether or not a suit would be fruitful for that. But that handles arrests made without probable cause. In order to have a lawful arrest, you have to have probable cause, and that's why they call it a search incident to lawful arrest, because if the arrest isn't lawful, then the fruits of that search are going to get suppressed. So you can't take it out of the reasonable suspicion category. Detentions on the street, he wants to continue on that street detentions as well as traffic stops are custodial arrests. Detentions are not custodial arrests. You saw that in Terry v. Ohio, that a detention is not an arrest. It uses a lower level of proof, reasonable suspicion versus probable cause. It's not. It just isn't. And going on, he wants to go back to the statement that the counsel for Kansas counsel stated that traffic stops are less intrusive than custodial arrests. And he says that Too Truth for Liberty, Too Dumb for Lawyer, says that traffic stops are custodial arrests, and they're not. Again, it's less intrusive because the officer can't do a search incident to a lawful arrest. That's less intrusive. He can't pull things out of your pockets. He can't cup your groin. You know, it is less intrusive. He's not taking you down to the police station for a strip search. It's less intrusive. And again, that's covered in Delaware v. Prowse, it's covered in Berkemer, it's covered in Knowles, it's covered in Rodriguez. All of those cases had language mirroring what that lawyer said. That lawyer was putting the words of the Supreme Court into his argument in front of the Supreme Court. He was on solid ground with that argument. The court is not going to take objection to that argument. His argument was sound. But going on to the facts of Kansas v. Glover, the facts are the officer ran a plate. I think it was maybe an automatic reader. I don't know. But it came back the owner had a suspended license. The officer had reasonable suspicion at that point, right? Or that's actually what's in front of the court. Did the officer have reasonable suspicion at that point to pull over the vehicle to determine whether or not the owner with the suspended license was driving? Well, the facts of the case are the cop did pull the vehicle over. It was in fact the owner who did in fact have a suspended license. The officer issued him a citation for driving on a suspended license and let the guy go. That is not a custodial arrest. Did the officer have the discretion to make a custodial arrest? Yes, which I know that Too Dumb for a Lawyer didn't want to hear, but that's what I was reading in those Kansas Vehicle Code statutes. If it is a misdemeanor, which driving on a suspended license is, the officer has the discretion on whether or not to make an arrest, to make a custodial arrest. He's already made the stop. He's determined that there is a misdemeanor, driving on a suspended license. He then has the discretion of whether or not to take the guy into custody at that point. Take him in front of a magistrate. If the magistrate says there's probable cause, bada boom, bada bing, off to jail you go. The officer did not exercise that discretion. There was no custodial arrest. What is in front of the court isn't a rehash of whether or not a traffic stop is a custodial arrest. That is settled. There is a long line of cases that have settled that argument. It is simply not a custodial arrest. It's not an arrest, period. It is a seizure, but it is not an arrest. What is in front of the court is whether or not the owner of a vehicle having a suspended license, if that gives the officer reasonable suspicion to make a stop, to make an investigatory detention, to stop the vehicle, to make a traffic stop, to verify the license of the driver. That's it. So what I hope everybody learned today from this is that if the officer makes an arrest without probable cause, then the fruits of the search incident to lawful arrest, everything the officer learned and uncovered based on the arrest, is most likely going to be suppressed. Thanks for watching. Have a great day.